Good afternoon. First of all, I would like to thank the organizers, NHRC, for giving me this opportunity to say a few words about and share my experience on human rights based approach to development. The title that I have considered for this presentation is Human Rights Based Approach to Development, a reality or a work in progress for international financing institutions. The theme of this presentation for understanding several concepts in a combined manner, the development, human rights, and human rights based approach, is already an interesting topic. So we need to understand the three things in three different segments. First, to understand development. What is development? Development is a process of economic and social transformation aimed at improving the well-being of people and reducing poverty, which is based on complex cultural and environmental factors and their interactions. Traditional welfare economics focused on income as the main measure of well-being. But Amartya Sen, the Nobel laureate, in his groundbreaking work in the 1980s, showed that poverty involved a wider range of deprivation in health, education, and living standards which were not captured by income alone. In 1999, Amartya Sen moved this goalpost with his argument that freedoms constituted the ends in development, not only the means. Sen's view is now widely accepted. Development must be judged by its impact on people, not only by changes in their income. Countries should also ensure adequate distribution of these improvements, not just satisfy themselves with a societal average. But then the second question would be, why development? In substance, the act of development recurs for three reasons. When there is insufficiency, when there is inequity or inequality, and when there is injustice. Insufficiency can be measured, through the World Development Reports, the GNP per capita, purchasing power parity, natural resources. It can be in a variety of ways. Inequity are measured through social indicators. Access to opportunity, discrimination, all are measures in this category. And injustice is when you see problems of inadequate laws, lack of access to justice, high cost of justice, lack of infrastructure, and lack of awareness. All these are part of elements that allow scholars to measure injustice. In general terms, the choice should be for providing food, health, and shelter, along with a much needed and comprehensive guarantee for eliminating injustice against the weak, the vulnerable, and the marginalized, and ensuring access to justice in the context of a completely independent judiciary. It also involves eradicating inequity by mainstreaming opportunities for all, and most importantly, extirpating insufficiency by promoting growth accompanied by proper distribution of wealth. And you will notice all the above clearly touch upon the notion inherent to human rights. So then we have to see what is the nexus of development and human rights. In 1986, 4th of December, the United Nations General Assembly adopted a resolution which contained the Declaration on the Right to Development. It aimed at furthering the development of a normative regime to deal with underdevelopment. But it was a logical and evolving culmination of a movement that had started with the United Nations Charter and the Universal Declaration of Human Rights and had continued through the period of anti-colonial struggle. Once the right to self-determination was no longer challengeable as a political entitlement, attention shifted to its socio-economic corollary. The Declaration on the Right to Development was also the fruit of a lengthy process of international campaigning for human rights, perceived as an integrated whole consisting of all civil, political, economic, social, and cultural rights. Note that the Declaration defines development as a complex, subjective, multidimensional, integrated, and a dynamic process which, through multiple interactions in the economic, social, cultural, and political spheres, generates continuous progress in terms of social justice, equality, well-being, and respect for the fundamental dignity of all individuals, groups, and people. Based on the principles of equality of rights and self-determination of people, the human person and all people are recognized as central subjects, not only objects of development and its driving force. Therefore, development must originate from popular participation based on equality in a process of integrated economic, social, and cultural development in accordance with people's aspiration to progress and well-being. The international dimension of the right to development is the duty of cooperation or the duty of solidarity. The developing countries want to mainstream the right to development in the current international economic rules and policies. But the developed ones, or the most affluent ones, are reluctant to concede this demand. They argue that they have no legal obligation to provide assistance to developing countries for their economic development. Because of this, the right to development is still a bit controversial, a third-generation human right. Controversies surround the concept, its status as a human right, the legal position of the right holders and the duty bearers, the mechanism of its implementation, and a juridical definition of the word development. Now let's talk about human rights-based approach. Human rights-based approach is a conceptual process framework for development programming that is normatively based on international human rights standards and operationally directed to promoting and protecting human rights. It is about turning human rights from purely legal instruments into effective policies and practices. It is based on the fundamental principles of human rights. They are universality, because they apply to all human beings; indivisibility, because they all have equal importance and cannot be ranked, whether economic, political, civil, cultural, or social; inalienability, because they cannot be taken away; and interdependency, because they influence each other and cannot be fully enjoyed independently. The implementation of human rights-based approach relies on 5 working principles to identify states and their institutions as duty bearers that are accountable for respecting, protecting, and fulfilling human rights, and individuals as right holders that are empowered to know, to claim, and to enjoy their human rights on which they have entitlements and claims. Applying all human rights for all acknowledges that human rights are legally binding state obligations. It calls for considering all human rights for everybody. This does not mean that an action should focus on all human rights at the same time. Rather, to understand the linkages and interdependence of the human rights at stake. Meaningful and inclusive participation and access to decision making is another element. It ensures participation in development process. This means putting rights holders at the center of the action by empowering them to identify and help address the main obstacles and structural barriers impeding them from enjoying their human rights. Non-discrimination and equality is another element. It acknowledges that all human beings in all their diversity are entitled to the protection and enjoyment of their human rights. In practice, this means interventions must assess patterns of inequality and discrimination in terms of protection, advantages, and opportunities. This also means identifying those who are facing unequal access to and control of resources, goods, and services, and rectifying the gaps with specific laws, policies, and institutional measures. Another element is concerns accountability and rule of law for all. This element actually calls for upholding state institutions to their highest standards in realizing and protecting people's human rights and promoting accessible, transparent, and effective mechanism of accountability and respect for the rule of law. It entails to ensuring that right holders can claim their rights and seek justice, redress, or compensation for violations through accountability mechanisms, including through a justice system that is available to all. Another element is transparency and access to information. This presumes the right to information, actually. State institutions become more accountable with transparent, reliable, and trustworthy information available via policies. A range of stakeholders can play an important role in ensuring accountability and transparency, including state institutions that are actually duty bearers, parliaments, supreme audit institutions, ombudspersons, national human rights bodies, or anti-corruption commissions, as well as other actors independent from the state, including civil society, private enterprises, and the media. In 2015, the United Nations General Assembly, through a resolution, adopted the Sustainable Development Goals. These goals sought to create a global development framework to succeed the Millennium Development Goals, which had ended that year. On 6th July 2017, these Sustainable Development Goals were made more actionable by the United Nations General Assembly resolution that identified targets for each goal and provided indicators to measure progress. From an international law perspective, the Sustainable Development Goals have the status of soft law. There are 17 Sustainable Development Goals, and each one of the goals is linked to one or multiple provisions of the human rights instruments that are available. Human rights based approach, let me say United Nations first. Let me add that the United Nations is founded on the principles of peace, justice, freedom, and human rights. The Universal Declaration of Human Rights, which recognizes human rights as the foundation of freedom, justice, and peace. The Vienna Declaration and Program of Action states that democracy, development, and respect for human rights and fundamental freedoms are interdependent and mutually reinforcing. With this background, in 1997, the Secretary General of the United Nations, while launching the UN Program for Reform, called on all entities of the United Nations system to maintain and to mainstream human rights into their programs within the framework of their mandates. For that purpose, several UN agencies developed a common understanding. According to that common understanding, all programs of cooperation, policies, and technical assistance should further the realization of human rights as laid down in the UN Declaration of Human Rights and other international human rights instruments. For instance, human rights standards contained in and principles derived from the Universal Declaration and other international human rights instruments guide all development cooperation and programming in all phases of the programming process. And such development cooperation contributes to develop the capacities of duty bearers to meet their obligations and of the right holders to claim their right. It is important to note at this juncture that a set of program activities that only incidentally contributes to the realization of human rights does not necessarily constitute a human rights-based approach to programming and development cooperation. The aim of all activities should be to contribute directly to the realization of one or several human rights. Now let's turn to the slight difference between the United Nations system and the international financing institutions. In the context of human rights-based approach, a differentiation between the role of the UN agencies and the Bretton Woods institutions, the major actors in financing development in countries, should be made. It is important that such a differentiation be made. Indeed, the agencies and institutions under the UN system, because of their charters and mandate, have practically all the rights to intervene with human rights agenda. But the IFIs, the international financial institutions, are not in that position. They face many challenges. With a varying degree of differentiated mandate, these financing institutions can provide both direct and indirect sovereign and non-sovereign backed financing. Although these international financing institutions are created predominantly for financing development, due to this different set of policies and strategies, they also face obstacles in terms of defining projects in countries, institutions, governance, policy or geopolitics related, and country or region specific. Constraint of mandates are important to consider. With minor variations These international financial institutions observe similar principles of governance. They all have boards of governors, which are their highest decision-making bodies, generally consisting of one governor and one alternate governor from each member country. Board of governors retain significant authority on substantive matters, for instance, quota reform or amendment to the constituent instruments, but delegate much of their decision-making power to their boards of executive directors. The board of executive directors, which are responsible for providing oversight to the operations, consist of several directors representing member countries through constituencies. The constituencies are generally divided according to quotas, and this is where we talk about the weighted representation, with some member countries representing only themselves and considered as a single member constituency. One particular significant dimension of the weighted representation is the relative command over the means of shaping public perception of debates about policies and standards, which to an extent constitute strong elements of politicization. Certainly, most IFIs or international financial institutions are supposed to be apolitical because of their charters, which prohibit them from interfering in the political affairs of any member. They actually cannot be influenced in their decision by the political character of their members concerned. All decision making is to be based on economic considerations. They also have constraints of policy and strategy. But before that, the constraint of, while talking about constraints of mandates, we still have to note that with all the policies and all the mandate, IFIs are always considered as controversial institutions in the world of development policy and practice. Why? From one point of view, they set the agenda for most of the other actors engaged in international development work. From another point of view, the constraints, the policies that they impose by virtue of their governing bodies being controlled by big shareholders perpetuate many of the underlying problems confronting developing countries and issues of rights. They confront a wide variety of political and practical problems in their dealings with other actors in the development process. Because of this inherent tension, they are faced with challenges regarding the scope and approach taken in the design of a specific project. They have a lot of policy and strategy constraints also. These institutions have thematic and operational policy instruments regarding a variety of sectors and coverage. These are tools designed to avail them the opportunity to maintaining, among other, an acceptable standard aimed at protecting the institutions, complying with the founders' wishes, and maintaining fairness amongst all. The necessary mechanism of control included in the operating procedures can be a challenge in applying a human rights-based approach in project design. Every time these institutions are called to finance an initiative, they must strive to diligently protect the institutional interest and to ensure that the financing is utilized efficiently in accordance with its existing policies. And then comes the need for them to mitigate constraints through other instruments. And this, by and large, are done in many IFIs through environmental and social government framework documents. Being subjects of international law, international financial institutions are expected to ensure that the projects they finance are not in violation of the applicable norms of international law. Their policies are designed in full recognition of and respect for sovereign equality of states, and their practice is to remain fully consistent with and faithful to the concept of territorial integrity of states. Projects are subjected to the principles which derive from and are also consistent with the numerous international treaties related to environment, climate change, cultural properties, biodiversity, and so forth. Backed by the internal processes, these IFIs naturally prefer to operate in a safe environment, and thus often show a tendency of getting involved in all upstream and downstream effects of projects they finance. This also compels them to ensure that all legal and institutional instruments are in place before the approval of the project, but also avoid any sensitive theme. And note that some human rights themes may be considered as controversial. That is where some creativity is needed, and that creativity is provided by these institutions, environmental and social governance framework documents, instruments of operation, which help follow a human rights based approach in project planning. This can be done through environmental and social assessment, environmental social management, disclosure, consultation, grievance mechanism, standards regarding land acquisition, standards regarding involuntary resettlement, dealing with indigenous people, and so forth. The main objective of these ESGF documents are to reflect institutional aims to address environmental and social risks and impacts in development projects, to support the environmental and social soundness and sustainability, and to facilitate the integration of such aspects into the decision-making process by all parties. This also is aimed at providing a framework for public consultation and disclosure of information, to provide a grievance redress mechanism designed to enable project affected people to voice their concerns. With the help of these ESGF instruments and some specific targeted actions, by and large, the international financial institutions apply human rights based approach to development. These ESGF instrument, or in the context of these ESGF instruments, IFIs support sustainable infrastructure and other productive sectors to promote economic growth and improve people's lives. Consistent with the Sustainable Development Goals that we discussed earlier, they recognize the need to address the three dimensions of sustainable development: economic, social, and environmental, in a balanced and integrated manner in the identification, preparation, and implementation of development projects. The IFIs also believe that social development and inclusion are critical for sound development. For them, inclusion means empowering people to participate in and benefit from the development process in a manner consistent with local conditions. Inclusion encompasses policies to promote equality of opportunity and non-discrimination by improving the access to poor, or access of poor, disadvantaged, and disabled people to education, health, and social protection, housing, environmental quality, infrastructure, affordable energy, water and sanitation, employment, financial services, and other productive assets. It also embraces action to remove barriers against vulnerable groups who are often excluded from the development process so that their voices can be heard. The international financing institutions seek, through the projects they finance, to be supportive of these human rights and to encourage respect for them. But for the principles of environmental and social sustainability to be effectively integrated into policies, strategies, and projects, these institutions also believe that these principles should become part of routine decision-making process. Environmental and social risks and impacts receive full consideration in the identification, preparation, and implementation of all projects. And the leading role is played by the clients. They are responsible for the preparation and implementation of their project, including management of the environmental and social risks and impacts. Within countries, at lower level, many preparation activities are community driven. So, to do that, stakeholder engagement is extremely important. Indeed, transparency and meaningful consultation are considered essential for the design and implementation of a project. Meaningful consultation is a process that begins early and continues throughout the project. It is inclusive, accessible, and timely, and is undertaken in an open manner. It conveys adequate information that is readily accessible to stakeholders in a culturally appropriate manner, and in turn enables the consideration of stakeholders' views as part of decision making. IFIs also believe in gender equality, which is necessary for sustainable economic development and all improvement of lives. They seek to support projects that make infrastructure equally accessible to all people and that provide equal opportunity for socio-economic development. In that context, they support their clients to identify potential gender-specific opportunities as well as adverse risks and impacts under the projects. To also develop mitigation measures to avoid or reduce such risks and impacts, and to enhance the design of their projects in an inclusive and gender-responsive manner, to promote equality of opportunity and women's socio-economic empowerment. Last but not least, the IFIs also believe that including persons with disability in the development process contributes to sustainable development. Consequently, they support their clients' efforts to empower such persons, identify sustainable solutions that make project more inclusive, and provide equal opportunity to persons with disability, including equal access to public facilities and services, and enable persons with disabilities to live independently where feasible and to be included in the community. Maybe somehow slow. And how can let me conclude this presentation by saying that maybe IFIs have been somewhat slow, but the progress made by the international community is real. Nonetheless, for a human rights-based approach in development to become a fully fledged and automatically observed method, all sides have to work harder. The international financial institutions should continue to bring new instruments and products to facilitate this human rights-based approach. The countries should continue to work harder to issue all necessary implementation legislations to allow the operationalization of their international commitments with the countries, within countries, including to share all the available data, thus for them to be at par with their international obligations. A more complete set of implementation-ready obligations will also help facilitate the human rights bodies in a meaningful way. So to end, I would like to recall what René Cassin, a French politician, noted while drafting the UN Declaration of Human Rights in 1948. He noted, and I quote, "It would be deceiving the people of the world to let them think that a legal provision was all that was required, when in fact an entire social structure had to be transformed." Hence, my view is that even after 75 years, work needs to continue.